Good morning, everybody, and thank you very much for making the time to be here today. At the outset, let me express our disappointment in the judgment that has been handed down today. As a party that respects the rule of law and the Constitution, we respect the judgment. However, we do believe that a number of errors in law and in interpretation have been made in this particular judgment, particularly at Section 40D of the judgment, where the courts refer to what they call a bright line between state and party that is observed. It goes without saying that influencing government decisions is not the same as political meddling in the affairs of government. We believe this is a significant underestimation of the scourge of cadre deployment and its terrible effects on the South African life and the circumstances in which many of us and our citizens find ourselves in today. It also flies in the face of the comments made by the then Deputy Chief Justice Zondo at the Zondo Commission, who said that it should be illegal for anybody to influence the appointment of people based on nothing other than their party affiliation. We maintain that the practice of cadre deployment is a violation of the constitutional provisions, which says that nobody should be discriminated or advanced on the basis of their party affiliation. And we believe that the judgment has missed out on this significantly. We believe too that the recently released cadre deployment minutes, which are now in our possession, and which we are busy collating, compiling, and putting into a searchable database, flies in the face of the court's so-called suggestion of a bright line between the state and party. The minutes, as we've already seen from information that is now in the public domain, went so far as to influence judicial appointments and various other key appointments across the state. This is a clear violation of the principle of the separation of powers, and we believe that the court has not taken the terrible effect of cadre deployment into account in this particular matter. Cadre deployment is not some benign practice that inflicts no harm. It is a malignant practice that has infected and bedeviled every aspect of the state. Cadre deployment is also not a victimless crime. Every time the lights go off, every time a factory is shut down, every time that water stops running in taps, every time one of the state-owned entities fails to fulfill its responsibilities and requires another big bailout, is as a result of cadre deployment. And you can track back the terrible appointments made to many of these key institutions that have hollowed them out so dramatically that they are unable to perform even their most basic of functions. Ports that cannot operate effectively, an electricity generator and supplier that cannot generate or supply electricity, taps running dry across the country, hospitals that do not have sufficient nurses and doctors. These are the human face of those who suffer from cadre deployment. What we will be doing is appealing this judgment. Our legal team is busy as we speak, digesting the judgment, but we will appeal it to the SCA and potentially directly to the Constitutional Court. We believe there can be no greater constitutional imperative than to deal with this particular matter and its effects on South Africa. If cadre deployment is continued and supported in its current form, it will continue to undermine the state and it will continue to cause great harm to the South African people and their prospects for the future. I would, however, like to add that today we know the date of the election. And the silver bullet to end cadre deployment once and for all is actually a few months away. We don't need to wait for long drawn-out court processes and appeals. We can end cadre deployment with a silver bullet on the 29th of May. And that silver bullet is by voting the ANC out and voting the DA into national government. We have made a commitment, and I repeat that commitment to each and every South African today, that should we be in a position to be a national government, we will, within the first 100 days, table in Parliament the End Cadre Deployment Bill, which will end this practice once and for all political parties in South Africa, to ensure that we have an independent civil service that is free of political interference and where people are appointed on merit and ability to do the job, not on the color or style of the membership card of the party they belong to that sits in their back pocket. These fights are never easy, and we bring these fights on behalf of the South African people. People who have written to us in recent days, and both you and I received a very impassioned email from a civil servant that had been pushed out of advancement and opportunity and watched as his years of experience were simply pushed aside in favor of people who are higher up in the party echelons. It is that is driving excellence from our public service. So, we may not have made it over this first hurdle, but I can assure you, like any elite athletes, we will get up and we will get back onto that track, off to the SCA, off to the Constitutional Court, and I commit to all South Africans that we will never, ever, ever stop fighting until this scourge of cadre deployment ends. But if you want to see it coming to an end, if you want to see the end of this policy once and for all, the easiest, quickest route to do so is by using your vote on the 29th of May to vote the ANC out and to vote a new government in that's going to introduce merit, ability to do the job, and excellence back to our civil service. So not only can we get our civil service working again, we can get South Africa working again, but we can also get the huge number of South Africans who are now unemployed working again. Thank you very much. I'll now hand over to Dr. Leon Schreiber, and then we'll obviously take whatever questions you may have afterwards. Thank you.
Thank you very much to the federal leader, John Steenhuisen, and thank you very much to all the media colleagues who came out today. I want to make one important point right at the start. This fight did not start yesterday, and it will not end today. The DA has been fighting against cadre deployment since its introduction back in 1997 at the Mafeking conference of the ANC. All the way back in the year 2000, the DA's predecessor published a document called All Power to the Party, which warned of exactly the consequences that cadre deployment would have on the state. The dry taps, the electricity running out, the failure of infrastructure. That is now the warning that has come to pass. And over the last 5 years, we have similarly worked tirelessly against this issue. We have introduced an end cadre deployment bill in Parliament, which was supported by every opposition party. It was only the ANC that stood against it. We have submitted dozens of parliamentary questions. We have won 3 different court cases to gain access to the ANC's cadre deployment minutes. And we will now pursue this particular fight with exactly the same vigor and focus that we have pursued all other elements of this particular campaign. This is not a battle against cadre deployment. This is a war against corruption. And a war has battles, but it has an ultimate victor. The DA is going to emerge as the victor on this front because we are going to defeat this scourge. As Mr. Steenhuisen says, we are considering direct application to the Constitutional Court because there can be no more serious constitutional matter than the question of a political party destroying the independence and capacity of the state and the civil service. I want to go a step further about the election. The 29th of May, following this court judgment today, the 29th of May has just become a referendum on cadre deployment. The power is now in the hands of the people of South Africa. We will continue this fight. We will pursue it all the way up to the Constitutional Court. But we know how long it takes. We know the delays involved. Trust me, I just spent 3 years trying to get hold of cadre deployment documents. So if you don't think South Africa has another 3 years, if you don't want to wait another decade and watch things collapse around you, then you have the power to vote in the referendum on cadre deployment on the 29th of May. The DA is the only party that not only talks about a capable state, but fights for it actively and delivers it where we govern. That is why we have pledged as one of our 7 apex priorities that we will abolish cadre deployment within our first 100 days in government. So this court's ruling today is a message to the people of South Africa. The power is now in your hands. Do you want to continue with failing service delivery, with load shedding, with dry taps, with unemployment? Or do you want to set South Africa on a better path where we employ the best among us to serve the most vulnerable among us? That is the referendum on cadre deployment that this country will confront on the 29th of May. Thank you.
Thank you, Dr. Schreiber. Colleagues, we'll now open for 2 rounds of questions. May we please, in the interest of time, restrict it to 2 questions at most per person and also to the matter at hand. Kenny Mapanga.
SABC, both to Mr. Steenhuisen and Mr. Schreiber. I mean, this is a judgment by a full bench. One could consider that to be quite a strong judgment. I mean, do you really think it's successful at this point to try and appeal further? And does this judgment not uphold the fact that it might not be the policy itself, but rather the scourge of corruption that may be taking place or you may be identifying in these different institutions?
Thank you. Alpha Ramashwana.
Alpha here from you received the ANC's documents 2 days ago. Will you be making those documents public? And number 2, I assume that you've assessed those documents, and what have you found within those documents? Thank you.
Thank you. Any hands, colleagues? Okay, Kevin.
Kevin from ENCA. John, I just want to know, do you see this judgment taking the punch out of whatever announcement? I believe that there's going to be an announcement on Friday on the content of the documents. Do you see that this judgment takes the punch out of whatever you'll be sharing then?
Okay, over to you, John.
Thank you. I think that what we'll be releasing later this week, if we decide to go down that path and the documents are ready, will be a punch to this judgment. Because this judgment refers to as I said, this clear line. What those documents demonstrate very clearly is that there is no line, and that people are chosen based on their loyalty to the party, their assessment and longevity of service to the organization, rather than on merit. We've already seen today how there was a direct interference in the operation and the independence of the Chief Justice and the judiciary. So I think that if anything, these documents that we've received are going to be a devastating blow to aspects of this judgment. And that is why we will include them now, the full set of minutes, in any supplementary legal papers that we bring, because it fundamentally disproves this court's assertion that this was some benign advisory system. It was not. It's very clear. You can trace the Cadre Deployment Committee's decisions being actively implemented, despite in some cases very grave reservations expressed from various other people. Cami, on your question, I think there are many full bench decisions that have been overturned in the Constitutional Court. And I remember that I'm reminded today of our battle around Nkandla. It took us to take that all the way to the Constitutional Court before we were able to actually see justice in a judgment handed down by Mogoeng. So I believe that the Constitutional Court is the right court to be seized with this matter, precisely because they are responsible for the interpretation of the constitutional matters. It is also why we have superior courts, the SCA and the Constitutional Court, because there's an acceptance even amongst the judiciary that they don't always get it right. And whilst I respect their judgment today, I don't believe they've got it right. And that is why we believe we will be successful in an appeal. And we believe that a court, looking now at the supplementation of the submission containing the minutes, etc., which now provide clear, direct evidence, could not come to another conclusion other than this is not a benign policy. It is a malignant policy that is causing a huge interference. May I also just make the point that the court, in deciding to release the Cadre deployment minutes to the DA and our PIA application, is further confirmation, we believe, that the exercise of a party power has had a direct influence in a exercise of a public power and an appointment power. The court would not have granted us access to the internal minutes of a committee of a party had they not believed that the actions in the decisions taken in those rooms ultimately resulted in a public action. And I believe that that will also strengthen the case going forward. Leon, I don't know if you want to answer the gentleman directly. Thanks.
Yes, thank you. Just to add, we mustn't forget the State Capture Commission's report as well when considering, Kenny, this particular question, because that report made it very clear that this practice was part of laying the foundation for the ultimate state capture. So the two clearly are linked, and that is part of the argument that we will put forward, in addition, of course, to what we've now found. I want to say about the records that today's ruling actually vindicates how important it was for us to pursue that again for 3 years through 3 different court processes, because those minutes, those records will now come into their own when we are able to actually take this forward and table devastating additional evidence before the court. I want to say to you that we are currently processing hundreds of these documents, and our undertaking all along is that we will make them public. It's just that some of them were very poorly scanned, some of them are difficult to read, and we have now also received hard copies. So, as often happens, the DA will have to fix what the ANC couldn't do. We will rescan the documents so that you can actually also read them and understand what is in there. I do want to say this morning, without being able to reveal in full detail what is in those documents, there exists in South Africa today a WhatsApp group for cadre deployment. A WhatsApp group inside the ANC that says, please forward the CVs of these people because there's currently a vacancy. There exists in South Africa today a database with the headline, Cadres for Consideration. Names of 171 individuals who are pre-selected inside the ANC for deployment. We have that database, and we are currently, as the leader says, making them searchable. There is no person in this country who could hear about a political party with a WhatsApp group that influences appointments, about a political party with a database of pre-selected cadres for deployment, and not understand that this is the fundamental reason we have seen service delivery collapse across society. And that is why we are going to make it public, so that the people of South Africa can judge for themselves, and as I've said, be informed on the day of this referendum on cadre deployment on the 29th of May that we know as the election. Thank you.